Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Cerenade e-immigration. In a time of change and uncertainty, e-immigration's case management system and dedicated team are here to help you keep calm in the chaos. Talk directly with the award-winning e-immigration team to see how their software can help you manage your cases, clients, forms, and firm with ease. Get a personal demo at get.eimmigration.com/demo or click on the link in the show notes. And of course, mention Immigration Review Podcast on your demo for a special offer. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Here I sit, in a hotel room waiting for day 2 of the FBA Immigration Law Section Annual Conference. Great panels and a great event already, including the powerful keynote address from Eastern District of Virginia District Court Judge Michael S. Nachmanoff. Important speech. Thank you, Judge. I also wait patiently to see what the Supreme Court is going to do about the ability for immigration litigants to obtain nationwide relief or injunctions in the birthright citizenship cases. Regardless of what the ultimate merits ruling is on that issue, oral argument just happened on the nationwide relief issue. Limiting a district court judge's ability to preliminarily enjoin or similarly preliminarily bar the executive would be an extraordinary ruling that previous presidents did not enjoy, and would have devastating effects for tens of thousands, if not more people, born in the U.S. who happen to live in the wrong state, until at least the Supreme Court rules on the merits of Mr. Trump's executive order. It's pretty wild. So it is heartening to read legal analyses of the Supreme Court's 7-2 ruling yesterday to essentially keep in place a preliminary bar on Mr. Trump's use of the Alien Enemies Act. Another terrifying bad faith example of executive overreach in the immigration space. As J. Coe writes, the majority seems to have held that when issuing preliminary relief, like a temporary restraining order at least, federal courts can recognize a provisional class of plaintiffs even before a class has been formally certified. Like, say, a preliminary class of people subject to the Alien Enemies Act, or a preliminary class of people born to undocumented parents throughout the United States. If that's the case, that would have had the same effect of nationwide preliminary injunctive relief, even if the Supreme Court eventually says that judges can't do that specifically anymore in the birthright citizenship case. Deep nerd, right? And don't get me wrong, that might run into other issues, at least in immigration, given the decision a few terms ago that holds that certain immigration issues can't be litigated as a class action. But still, it gives me hope. We need hope every day in the immigration world. And here's to the rule of law prevailing on the Alien Enemies Act issue. Preliminarily. NPR reports that Mr. Trump thanked Justices Thomas and Alito for their dissent. Hate to break it to you, but we have 5 cases this week and nothing particularly good for non-citizens. But if you've come this far, you're probably going to listen anyway. You should. All right, the BIA's big week. The first BIA case is a matter of FBGM and JEMG, published by the BIA. This is another procedural type case. Another case about deadlines and electronic notice. So listen up. And it's the third non-precedential BIA decision that the Attorney General has decided to make precedential. What's the guidance, y'all, and who is really making these decisions to publish non-precedential decisions as precedential? What is the guidance? It's gotta be FOIA, a bull. The respondents lost their asylum case in immigration court and appealed, timely. A year later, the BIA issued its briefing schedule and the necessary transcript of proceedings, necessary to actually make an appellate brief, and gave the parties 3 weeks to submit their briefs after waiting a year for the transcript, as is BIA practice, if not longer. But the respondents missed their briefing deadline, so the BIA summarily dismissed the appeal as the regulations permit, at least under these circumstances. Receiving that dismissal and freaking out, the respondents moved to reconsider the dismissal 9 days later. DHS opposed. The BIA denied the motion. The respondents alleged that neither they nor their attorneys received the briefing schedule through the mail or email, which I'm sure is true. They also alleged, though, that they didn't receive the ECAS email notification for this electronic case, which I am sure is possible, but does seem unlikely. Even more unlikely, possibly, given that the respondents also argued that, quote, the notifications sent through ECAS do not provide sufficient notice because they do not clearly indicate that they relate to a briefing schedule and do not provide the filing deadline in either the subject line or the body of the email, end quote. Which is at least partially true, at least the latter part. And anyway, the respondents argued that they had expected to receive the briefing schedule by mail, and that the BIA should have announced that they would no longer be sending briefing schedules through the mail with electronic cases in a public way. As the BIA explains, though, 2 years earlier, EOIR published a final rule about ECAS, a rule that went into effect on February 11, 2022. On that date, electronic filing became mandatory and users had to accept service through ECAS. As the BIA explains, ECAS sends an email when a document is uploaded onto ECAS, and the body of the email provides some information. Sometimes it even has an attachment. But you've definitely got to go to ECAS to make sure that you check to see what's going on the docket. The BIA then goes on for many pages, but essentially holds that email notice that a document, including a briefing schedule, has been filed on ECAS achieves due process and is otherwise proper. Quote, it is the responsibility of an attorney or accredited representative appearing before the board to review all documents served through ECAS, regardless of whether the documents are EOIR generated or filed by the opposing party, end quote. Hard to argue with that, or at least I don't. The BIA also reached down into its old in absentia reopening cases and held that there is a rebuttable presumption that email notifications sent via ECAS reached their recipient. And that, of course, quote, all relevant facts and evidence should be considered in determining whether a party has rebutted this presumption, end quote. The BIA lists a whole paragraph of factors, including affidavits that can be considered, but really, it's anything you can think of, right? If you are in the unfortunate situation of alleging that you never received email notification through ECAS and so missed a deadline, you can submit anything relevant. Quote, we caution, however, that in most cases, a bare denial of receipt will not be sufficient to rebut the presumption of delivery, end quote. Probably time to start getting affidavits from your tech people if faced with this unfortunate situation, and possibly even creating an entire process with your tech people to make sure it never happens. A process that you can then argue in the future if it does happen, right? Here, counsel's, quote, affirmation, end quote, that she searched her email and could not find the notice is insufficient to rebut to the BIA. And the 2021 rule provided sufficient notice to the parties that electronic notices were going to be issued. That the BIA has also been sending hard copies in some cases, that is, hard copies of briefing schedules for electronic cases, is a non-binding courtesy that the BIA is not bound by. Nor does the BIA see this as the type of case that, a la matter of Morales, episode 158, it will equitably toll a briefing schedule for. Seems like counsel moved, but, quote, the respondents have not shown that their counsel's office move prevented counsel from checking email or from timely filing the brief, end quote. But if it had. So here the respondents do not get their appellate briefs considered. Allow me, please. First, let's all take a step back and simply recognize that some responsibility for the confusion must lie with EOIR, which still has thousands of old paper cases that it refuses to make electronic. And I could be wrong, I really could, but I'm not sure that immigration court paper cases necessarily become electronic once an appeal is taken. Could be wrong. But regardless, busy attorneys may make a mistake in their recollection about whether a case is electronic or paper when things are happening all over the place. Not excusing it, just saying. More importantly though, and I believe I've said this before, so listen up, BIA. While you are issuing decisions that make it nearly impossible to forgive mistakes made by attorneys who receive electronic notice via email, may I suggest some fixes to the system on your end? Namely the fact that, again, unless I'm mistaken, non-lead attorneys do not receive email notices when things are filed in ECAS, which is insane. And it's a big deal too, when, for example, a senior partner may enter their appearance as a lead attorney, but it is in fact a more junior attorney primarily responsible for the matter. Many law firms operate in this way. An electronic system that does not provide email notification to non-lead attorneys when something is filed on the docket is very dangerous, prejudicial to older attorneys, and ignores how many law firms operate. Not to mention there's no cause for it. The BIA notes that its ECAS system is similar to how the federal courts operate, but this part is contrary to how CMECF operates. CMECF provides email notification to all attorneys who have filed an appearance, and even lets you tether multiple email addresses to a single attorney's email, for example, to make sure that nobody misses anything. The failure of ECAS to provide this is probably a tech oversight, if I'm being honest. Might I politely suggest that you fix this before another otherwise ethical and studious law firm misses a deadline? And that is a matter of FBGM and JEMG. Next is a matter of MSI, published by the BIA. This case is about Convention Against Torture Acquiescence. And you're not going to believe it, because it's so shocking, but it's another previously unpublished BIA decision that someone at the BIA alerted the Attorney General to, and so the Attorney General, or her designee, has decided to make precedential. It does make one wonder why the Attorney General under the last administration didn't decide to use this seemingly very expansive power, even one time, if I'm not mistaken. Doesn't it? The Fifth Circuit had sent this case back to the BIA on joint motion from the parties. The BIA has now dismissed the appeal again. Mr. MSI, an acronym, is from Nepal and fears the Maoist party in that country. It seems that the Fifth Circuit sent the case back only for a future persecution and CAT analysis, so that's what the BIA did. I guess the Maoist party isn't in government in Nepal? I don't know, it must not be, given that the BIA says that the respondent, quote, did not show that he was targeted by anyone other than private actors, end quote, and that the Nepalese government was unable or unwilling to protect him, which of course is the asylum and withholding of removal government nexus standard. After all, explained the BIA, Mr. MSI never reported the harm that he suffered, and his belief that it would have been, quote, fruitless, end quote, without more, doesn't excuse him from this reporting pseudo requirement that has developed in asylum and CAT law. Plus, in the Fifth Circuit where this case arises, quote, one would be hard-pressed to find that the authorities were unable or unwilling to help the respondent if he never gave them an opportunity to do so, end quote. That's Sanchez Amador v. Garland, episode 103. Without citing the cases, the BIA recognizes that this might not be the law in all circuits. But we are in the Fifth Circuit in this decision, and so no future persecution claim, explained the BIA. Turning then to the Convention Against Torture, that of course requires a showing that, quote, it is more likely than not that a respondent will be tortured by, at the instigation of, or with the consent or acquiescence, to include willful blindness, of a public official or other person acting in an official capacity, end quote. Little standard for you all, quote, acquiescence to torture requires that the public officials remain willfully blind to torturous conduct and breach their legal responsibility to prevent it, end quote. Some attorneys are trying to make pretty good law in the First Circuit, at least, about what that legal responsibility is. And so we wait. For purposes of the Fifth Circuit in this decision, arguments that officials are corrupt and the Maoists are powerful and connected to the government in Nepal won't cut it. At least on this record, quote, the potential for private actor violence coupled with a speculation that police cannot or will not help is insufficient to prove acquiescence, end quote. Probably wouldn't cut it for unable or unwilling to protect either when said like that, but definitely not for cat acquiescence, explained the BIA. Too much supposition, explained the board. Always too much supposition, right, when it's a cat denial? Let's be honest. Has there ever been a more important decision to deny cat cases than matter of JFF? Quote, the evidence reflecting corruption and impunity in the Nepalese police force or that Maoists hold power does not inherently mean that authorities would be willfully blind to private actors torturing this respondent, whose political party also wields notable political control, end quote. If you're going to rely on generalized corruption to try to meet your government nexus, for withholding or cat protection, it seems, you better connect it to, quote, the particular circumstances, end quote, of your case to even have a chance. And with that, the BIA dismissed the appeal, precedentially. And that is matter of MSI. Still with the BIA this week. Matter of Q. Lee, published by the BIA. This case is about bond. Thousands of non-citizens without criminal records are not eligible for an immigration judge to give them one, explained the BIA. Ms. Lee is from China and entered the United States without authorization in June 2022. She was apprehended 100 yards north of the border and about 5 miles away from a port of entry. The DHS officer arrested her without a warrant to do so and took her to an immigration prison. DHS released her the very next day on parole pursuant to I&A Section 212D5A, the type of parole that would definitely permit her to adjust to LPR status if she, for example, married a U.S. citizen or if she was a Cuban. Turns out, though, that she is wanted in Spain for travel document forgery and human smuggling crimes because Spain requested and Interpol issued a red notice in October 2024. That doesn't constitute probable cause that she did the crime under the Department of Justice's own guidance, but also not a great look. Because of this, ICE detained her at her regular ICE check-in and initiated removal proceedings, charging her as having entered without inspection and as inadmissible under I&A Section 212A6AI. When she requested an opportunity to explain herself to an IJ and show why actually she warranted a bond because she's neither a danger nor a flight risk, and who knows, maybe there's more to the Interpol notice than meets the eye, the IJ held that he could not even entertain the request for the opportunity for her to explain herself and make a case for bond. No bond hearing allowed, held the IJ, and affirmed by the BIA. Whether Ms. Lee is eligible for a bond depends on the legal fiction undergirding her detention. Is she detained under I&A Section 230B2A or I&A Section 236A? Inquiring minds want to know. Same human in the same prison with the same set of facts, but if it's the former, she can't get a bond hearing. It's the former, held the BIA. I&A Section 235B2A indeed does not permit IJs to grant bond hearings, but it only applies to, quote, applicants for admission, end quote. Under the statute, quote, an applicant for admission is defined in relevant part as a non-citizen who arrives in the United States whether or not at a designated port of arrival, end quote. As used in this decision, the BIA calls that an alien who is arriving, not to be confused with an arriving alien. But recall, Ms. Lee physically entered the United States, remember? How is she applying for admission? She's here. Well, there's been a legal fiction since 1996, and both I&A Section 235A1 and the Supreme Court permit DHS to treat some iwis as applicants for admission. As the BIA explains, under Thrasigum a few years ago from the Supreme Court, but really as Advocatus over 20 years ago, a non-citizen, quote, who is detained shortly after unlawful entry cannot be said to have effected an entry, and is in the same position as a non-citizen seeking admission at a port of entry, end quote. Policy-wise, I guess the rationale is that you don't want to give people who sneak in a better legal position than people who come to a port of entry and are then let in for removal proceedings. So that's the legal framework for applicants for admission. And then so too with the concept of arrival under BIA precedent. How short is shortly, though? That is the detention. Well, for the aliens who are arriving thing, the BIA has explained that it applies to people apprehended just inside the border on the same day that they cross into the United States. That's a matter of MDCV from 2020. So, seems like there might be a temporal limitation there. Combining all of this, the BIA sees Ms. Lee as a non-citizen applicant for admission who arrived in the United States as understood by I&N Section 235A1. And I know this is confusing, everybody. Should give the decision a read. This stuff always is. But when people are labeled like this by DHS, and to be clear, I believe it's up to DHS, DHS then also has the option to expeditiously remove such people, or alternatively, provide them the right of full-on removal proceedings before an immigration judge. Lots of power to DHS. For the expedited removal people, Bill Barr overturned years-old precedent in 2019 to hold that even if they become asylum seekers, they can't get released on bond. And that's even though in practice, once they're seeking asylum, they're in a very, very similar proceeding before an immigration judge getting their asylum case heard. That's matter of MS, and Attorney General Garland did not decide to vacate matter of MS, so it remains the law. Seems that it wouldn't really help Ms. Lee here anyway, even if Attorney General Garland had, explains BIA, because relying on language from the Supreme Court in Jennings v. Rodriguez, even applicants for admission in full-on removal proceedings must be detained during their removal proceedings. At least I suppose when they are also deemed aliens arriving under Section 235. Now Ms. Lee begs to differ. She argues that her detention is occurring under I&N Section 236A, the general immigration detention provision pending removal proceedings that very much permits bond hearings. The BIA disagrees, believing Ms. Lee is an alien arriving in the United States. Which again is not necessarily an arriving alien, it is confusing. And so expressly expanding Attorney General Barr's matter of MS not vacated by Attorney General Garland, and relying on Jennings, the BIA holds that Ms. Lee is not entitled to a bond hearing. Broadly holding, the BIA states, quote, an applicant for admission who is arrested and detained without a warrant while arriving in the United States, whether or not at a port of entry, and subsequently placed in removal proceedings, is detained under I&A Section 235B of the INA and is ineligible for any subsequent release on bond, end quote. I don't hear any limiting language there, do you? Could it maybe apply to someone caught near the border many years ago, soon after their entry and then released? Seems like those people could be subject to mandatory detention now, years later, and regardless of whether they have a criminal record, so long as DHS initiates removal proceedings? Seems that way. I could be wrong. If I'm not wrong, it's subjecting thousands of non-citizens who have lived in the United States for a very long time to mandatory detention. Nor can DHS be nice and issue a warrant for arrest alongside the initiation of those removal proceedings to convert the non-citizen's detention into a bond-eligible INA Section 236A detention, explains the BIA in a footnote. DHS can, of course, release non-citizens on their own. That's the parole. But DHS doesn't seem to be really inclined to do so at the moment, given directives coming from Washington, which of course is always the point of having a neutral arbitrator decide matters of physical imprisonment of human beings. Nor does it matter that here Ms. Lee was placed in removal proceedings rather than expedited removal. It's all about that initial arrest without a warrant, soon after their arrival in the United States, it seems, that transforms her into an alien arriving and applicant for admission who can't get a bond hearing. At least here once DHS terminated her parole. A bit astonishingly to me, the BIA does not provide guidance as to how shortly after an unlawful entry into the U.S. a detention must occur for this decision to apply to a non-citizen, and potentially allowing DHS to apply it to even more non-citizens than the decision already does by its plain terms. Again, read this decision for your clients and see if there's a line that you can walk with them, depending, for example, on whether they were ever detained near the border, and if they were, how shortly after their arrival and how close to the border their initial detention was. Because this decision also, of course, makes OSIP appointments all the more dangerous for so many thousands of non-citizens right now who are otherwise complying with their ICE requirements. Appellate immigration judge Mullane concurred. The appellate judge would deem Miss Lee an arriving alien, which is an additional way to deny her bond under the statute, although I believe such a ruling, if it was made, might conflict with Ninth Circuit precedent at least. Might. Go back and read the pod page. And that is matter of Q. Lee. Are you fighting like a maniac, completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle USCIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month. Eighth Circuit time. First, Soto Santos v. Bondi, published by the Eighth Circuit on May 12, 2025. This case is about motions to remand. Mr. Soto Santos is from Guatemala, has lived in the United States for a long time, and was denied asylum and related relief in immigration court. While his case was on appeal, though, his girlfriend gave birth to a child, quote, who enjoyed United States citizenship, end quote. That technically made Mr. Soto Santos eligible for non-LPR cancellation of removal because I guess he had the 10 years, and now he had the qualifying relative who may suffer hardship without him. No final order of removal yet either because the BIA hadn't decided his appeal. So he moved the BIA to remand so he could pursue this previously unavailable form of relief. Denied by the BIA and affirmed by the Eighth Circuit. To the BIA and the Eighth Circuit, the motion to remand standard is the same as the motion to reopen one, requiring Mr. Soto Santos, among other things, to make a prima facie case for cancellation to even get the chance to apply for it through a remand. Put efforts into your motions to remand, everyone, including on exceptional and extremely unusual hardship. Quote, he did not present any evidence of that. Before the BIA, Mr. Soto Santos was silent about the hardship his removal would cause to his daughter, and so the BIA had no basis to conclude that Mr. Soto Santos could present evidence of hardship sufficient to support his cancellation of removal. It permissibly denied Mr. Soto Santos's motion for that reason, end quote. You can't make a prima facie showing if you skip an element. By the way, I think you want to look at matter of Chen from the BIA if my memory right off the cuff is correct. Not only that, quote, to the extent that Mr. Soto Santos contends, lastly, that the Department of Homeland Security should not be pursuing his removal because he is not an enforcement priority under agency policies, he is making his argument to the wrong branch of government, end quote, which is true. Can't really appeal or challenge and certainly can't petition for review such things, at least not to my knowledge. Nor would such an argument likely sway the correct branch of government, the executive in the form of DHS, given that now, I suppose, everyone is an enforcement priority, potentially including you and me. For Mr. Soto Santos, that means he remains ordered removed. And that is Soto Santos v. Bondi. Our final case from the Eighth Circuit is Mohamed v. Bondi, published by the Eighth on May 12, 2025. This case is about competency determinations. Mr. Mohamed is from Somalia and entered the United States as a child refugee in 1998. He grew up in foster care for a time. He should have naturalized, but he didn't. It seems like he may have had a difficult youth and may have mental health issues. His, quote, criminal history is extensive, end quote. He was ordered removed after an immigration judge determined that some of his crimes qualified as aggravated felonies. Following a remand from the BIA, though, an immigration judge deemed Mr. Mohamed competent to participate in his removal proceedings, which had occurred in 2020 and 2021. This was in part due to a psychological report that believed him competent, but also opined that he was, quote, incapable of reasoning logically and understanding his legal situation, end quote, during the 2017 to 2018 time frame. Not sure what was going on during that time. The BIA then ultimately affirmed the IJ the second time, and that's what's at issue before the Eighth Circuit now, the competency determination. To the court, a competency determination is a factual question, meaning that with his conviction, I&N Section 242A2C bars review of it in federal court. That's what the Eighth Circuit held here. But that would be a boring decision if I stopped right there, so the court didn't either, for your listening pleasure. Digging deeper, the Eighth Circuit doesn't see a, quote, fundamental procedural error, end quote, with the IJ's competency determination. Rather, to the court, the IJ held a competency hearing where witnesses testified and considered the psychological report, and also considered observations in court and the totality of the evidence, as an IJ should. This despite the fact, though, that the IJ appears to have held in 2021, retroactively, that Mr. Mohamed was competent during proceedings in 2020. That's kind of weird, right? And the psychologist never opined in writing about the 2019 to 2020 time period. But the psychologist did testify that he believed Mr. Mohamed competent by 2020. So that's something. Unsure how that happens, though. That is, the differences in competency based on years. The Eighth Circuit isn't providing us many details in this decision. After all, explained to court, the IJ observed Mr. Mohamed extensively in 2020, and medical documents support the IJ's belief about Mr. Mohamed's competency in that year. Without a procedural error, the Eighth Circuit didn't even discuss whether an error prejudiced Mr. Mohamed, although with mental health, it probably would have. But again, no fundamental error. So Mr. Mohamed did not succeed. And that is Mohamed v. Bondi. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.